All right, as you prepare also, do you need expert witnesses? A lot of cases, if they need to prove anything that's outside of the scope of expertise of a normal layperson, will need an expert witness. This sometimes really messes up people who are trying to prepare for their case for the first time because they anticipate in, for example, a motor vehicle accident case that they're just going to go into court and present all of their medical bills. And unfortunately, if they don't have a doctor there to explain the treatment, the necessity of the treatment that was provided, and otherwise authenticate those medical bills, that evidence isn't going to come in. That would need an expert witness, either just an expert doctor that's retained as an expert or the treating physician. So, if you have medical damages, you generally need an expert. If you're going to require any sort of scientific testimony, you will probably need an expert. If you're going to need anything that attests as to the competency of a doctor, an attorney, a mechanic, any other profession, you probably are going to need an expert. So start looking at that from the very beginning when you look at what you need to prove. Can your case be established by just a typical witness, somebody on the street who sees it? Can you prove it with what the person saw, what the person heard, or do you need to have some sort of opinion rendered as to another topic? If you do, you're going to want to start looking for your expert witnesses as soon as possible. Getting an expert witness, if you're self-represented, is oftentimes very difficult. Not only do they tend to be rather prohibitively expensive, but a lot of expert witnesses don't like working with self-represented litigants. So you're going to want to start your request early, and if you're doing medical damages, one of the best places to start, of course, is your treating physician, because you already have a relationship with that person. One thing that you need to know is that either side in a lawsuit can ask for the simultaneous disclosure of expert witnesses. This demand can be made by either side and needs to be made no later than either the 10th day after the initial trial date is set or 70 days before the trial date, whichever is closer to the trial date. And the exchange date is going to be either 50 days before the initial trial date or 20 days after service of the demand, whichever is closer to that trial date. And at the time that that's done, each side then serves, typically by mail or in person, however it's arranged between the parties, a list of their experts, the CV of each expert, a narrative as to the anticipated testimony of that expert, whether the expert is retained, what the expert's fee is to testify and to consult, so that each side knows who the other side might be bringing as an expert and how much it's going to cost to depose that person. The effect of failing to do the simultaneous disclosure if it's demand is exclusion of your expert witnesses. So if one side, if that notice is served out and one side complies and the other side doesn't, the side that doesn't get to bring their expert witnesses in, which, given the importance of it, can be fatal to a case.
Can I ask you what that means? You write down a list. Simultaneous disclosure of expert witnesses means you just list them.
Well, there's going to be, and we've got more resources in the library on it, but it's a little more detailed than that. It's the witness, their qualifications as an expert, aka their CV, and other information about their rate for testifying, whether they're retained, and so on.
So if you have like a declaration from someone who could be considered an expert witness, but he's not planning to testify, you don't have to, you can still admit that declaration into evidence? Is that correct?
No, generally not, because, and as you'll learn when we talk about the hearsay rule, you usually need to have an actual witness attest unless there are a few exceptions to it or agreement of the parties. Now, some of your cases might go to what's called judicial arbitration before it goes to trial. If your case is going to be under 1 day, it's not going to go to judicial arbitration. Also, if your case is going to be certainly over $50,000 in dispute, not going to go to judicial arbitration, but other cases might. Judicial arbitration is where your case goes to a neutral third party, an attorney that's going to have at least 10 years of experience, who's on the arbitration board for the court, who's going to have your case heard in an informal hearing about 3 hours long, and is going to render what's called an arbitrator's award based on the evidence that's received from each side. This arbitrator's award, unless the parties agree in advance, is not binding. So that means that either side can choose to reject the arbitrator's award and then proceed to trial. However, oftentimes the arbitrator's award might stand just because if a side rejects an arbitrator's award and asks to go to trial, but doesn't do better at trial than they did at arbitration, they can be liable for all of the costs going forward from that arbitration to trial. All right. About a month or a few weeks before you go to trial, you're going to have a mandatory settlement conference. Mandatory settlement conferences in Sacramento take place in Department 59, and it's essentially each party or each attorney or each self-represented litigant, they go to the department, they get put together in a room to discuss the case. There's going to be typically voluntary attorneys or a pro tem judge that are there to help discuss the case, maybe apply a little bit of pressure on each side and see if there is any possible settlement that the parties can agree to. If the parties do reach a settlement, then that can be made into the order of the court and the trial date is vacated. If the parties can agree only to some things, that can also be made into the agreement of the parties and entered in by the court, and then trial would only be had on the issues that they disagree on. And one last thing you should know about it, prior to your mandatory settlement conference, you're going to want to prepare a settlement conference statement, which just is used by the settlement conference department to know what each side's position is, what their settlement position is, what prior offers have been made, and to help them quickly understand the case. And we do have a sample of that that's on the court's website that we've put in your packet. Now, a lot of you may have limited civil cases. These are cases under $25,000. If you have a limited case, there's an option for presenting evidence that's sometimes used and oftentimes in some types of cases, such as collection cases, which is to present a declaration in lieu of live testimony. This declaration in lieu of live testimony is authorized under Civil Code Section 98. Code of Civil Procedure, Section 98. And the side that serves this declaration, they basically will have a declaration of their witness, any evidence that that witness is authenticating and wants to have introduced attached as exhibits, and they're going to ask then at trial to have that become the evidence that, or part of the evidence that they're presenting. Now, they have to comply with a few things when they do this. Now, the one that I sometimes see problems with, especially, is that there has to be an address to subpoena the witness in the declaration that's within 150 miles of the court. And, and it's an address that they can be subpoenaed 20 days, within the 20 days prior to the date of trial. What I will oftentimes see is I'll see a custodian of records named in the declaration for some company. The person might not even be in state, but they will have an address of a law office that will accept service on their behalf within 150 miles. And that would be acceptable. But if you want that witness to appear, you will have to issue a subpoena to have that witness come to trial. Otherwise, if that witness is not subpoenaed, they can enter in that declaration in lieu of live testimony and not have the witness there. This might work for you or it might work against you, depending on the exact circumstances. So first thing you do if you happen to get a declaration or if you're sending one out is you're going to want to make sure this declaration is not technically defective. So for example, if it doesn't have that address within 150 miles and you object to it on that basis to the court, the declaration can't be entered. You're also going to want to make sure that if the witness is establishing certain elements in the case, well, are those elements actual facts relating to that actually alleged in the declaration? Do the documents that are attached support what is being said? For example, just a couple of months ago had a declaration that we saw where they had attached all the wrong accounts papers to it. So needless to say, if the other side didn't catch that and bring a live witness, it wouldn't establish anything in their case, because whether one person, whether I owe money is not determined by how much you owe or anybody else. So you're going to look for those, yes?
Isn't that declaration considered hearsay?
Well, that's part of the, there are certain, all of the rules will apply, but there will be exceptions to it, but that's part of why you're allowed to subpoena the witness. If you want to have the actual live witness testifying, you would have the opportunity to subpoena him or her. Otherwise, they would allow that in. Part of the idea behind this is in a case under $25,000, they want to make it a little easier for people to present their cases, if there's not a lot of compelling witness testimony necessary.
So if the case is over $100,000?
$25,000.
But if it's over 100, would they have to appear in person then?
Oh, absolutely, because it's not a limited case. Unless, of course, there's a few exceptions that would allow things like deposition testimony and so on to come in under some circumstances. All right. Next, even in these declarations, all of the rules for admitting evidence, all the rules of evidence still apply. So you're going to want to check to make sure that that any evidence, any exhibits in there are properly authenticated. We'll talk about authentication in just a little bit, but that's going to be things like, does the witness have personal knowledge of the subject, or is the person a custodian of records who's readily familiar with the process of the company? Are these, the documents that are being attached, they're likely going to be some sort of hearsay, but is there an exception to that, such as the business records exception, things like that. So once you've evaluated the declaration, and if you find those defects, then you make a strategic choice as to whether or not you're going to point out those defects and subpoena the witness, or let them go to trial with the anticipation that they're not going to have an actual witness to fix the problem. As you get ready, and as trial is starting to approach, you're going to want to get everything organized for trial. Trial is in many ways a blood sport, and your ability to proceed at trial is going to depend on your organization and your ability to easily access evidence and other, and other records and information that you need to access during trial. Inevitably, what's going to happen after your trial, whether you win or lose, you're going to be lying in bed at night and you're going to think, oh, I should have said whatever, and it's going to drive you crazy. Being really well organized allows you to have fewer of those moments. So most people like to create what's called a trial notebook. And there are many different strategies to create one. If you do many cases, you will find what works best for you. So consider these just suggestions as to ways you might organize it, and then adapt it to however you work, however will allow you to quickly and easily find your evidence and other documents. You're also going to want to subpoena every witness in your case, even the friendly witnesses. And the reason behind this is, let's say you've got your star witness, And on the way to court, you get a call that your star witness has been hit by a bus and is in the hospital for the next 2 weeks. And you go to the judge at the beginning and say, Your Honor, can we continue this? My star witness, I can't proceed without him, and he's in the hospital right now. First thing the judge is going to ask is, did you subpoena this witness? And if you say, well, no, the judge's response is going to be, well, I'm sorry, proceed with your case. On the other hand, if you've subpoenaed that witness, then the judge is going to ask if you want an arrest warrant for your witness, at which point you're going to say, no, he's going to appear once he gets out of the hospital. Or whatever the case might be, or if it's the other side, maybe you do want that arrest warrant. Yes?
You'd mentioned maybe showing a sample of a trial notebook. Is you going to show
I'm going to talk about the different tabs. And really, trial notebook, it's just a 3-ring binder, essentially. The other thing you're going to want to do is you're going to want to, any witnesses that you have, you're going to want to prep them. You're going to want to question them. You're going to want to make sure that they know what to expect. And we'll talk about that in a little bit of detail. You're also going to want to, if there's any evidence that you are anticipating that you're going to ask the court to exclude, because you've served discovery requests and they didn't disclose it during discovery, or maybe there's some evidence that's going to be really highly prejudicial to your side, but not really that relevant to anything else. Whatever the case might be, these are called motions in limine, and you're going to want to prepare those and have them ready to go. They're served 7 days prior to trial, but would be presented on the first day of trial. All right, and then the other thing that is required under the local rules, although oftentimes does not happen, is preparation of a trial brief. The local rules in Sacramento say, each party shall prepare a trial brief and present it at the first day of trial. With that said, for simple cases, most people don't, and that's because if you have, for example, a basic breach of contract case, there's not really anything that needs to be decided that's particularly novel. Judge usually already knows the law surrounding contract. On the other hand, if there are any novel points of law, if there's anything that's at all complicated in your case, you probably want to prepare a trial brief. This trial brief, especially if the other side doesn't prepare one, is going to let the judge know what issues of fact there are out there that need to be cited, what laws and special considerations exist, and also some briefings so that the judge can understand any unique aspects of law that are going to be important in your trial. It's more or less for the education of the judge, and if your case has any unusual points of law, it's very, very preferable to have a trial brief. Yes?
It also memorializes your case in case of appeal.
That is true.